Hello, everyone. This is Matt Danner. I'm the founder of a company called Monolith Forensics. I'm coming to you from Austin, Texas, currently. And what we're going to talk about today is what to expect from opposing digital forensic experts. So just a bit of an introduction about myself. I've been a digital forensics expert for a little over 10 years now. I've testified probably 2 or 3 dozen times in different court jurisdictions, including federal, state, and military courts, all related to digital forensics. In terms of the types of cases I've testified in, I've worked, probably hundreds for prosecution, probably worked on a few dozen for criminal defense, and then probably worked on a couple hundred for civil litigation cases, both as plaintiff's expert and defense expert. And all in all, like I said earlier, testified probably 2 or 3 dozen times, total accumulation of both hearings, depositions, court trial testimony, that sort of thing. And the vast majority of these, I would say probably at least half of these have had some kind of opposing expert on them, whether it be a defense expert or plaintiff's expert in civil litigation. Times where I was even the opposing expert as for the criminal defense side and vice versa. So just had a ton of experience, working cases with opposing experts and run into a lot of different issues and things that I've kind of picked up along the way. My current role right now is I run a company called Monolith Forensics. And what we do, I still do some consulting on the side. I have some attorneys that still like working with me, and they like to use me for certain types of cases. So I still do a little bit of consulting when necessary. But my full-time job is running the Monolith Forensics company, which primarily what we do with Monolith is we make case evidence analysis, lab management software for digital forensic teams and e-discovery companies. So if you work in an e-discovery company or a law enforcement digital forensics lab, or if you have a digital forensics consulting agency or any kind of digital forensics, that's the software that we make the software for you. It's productivity software to help you, manage your evidence, manage your cases, manage your tasks, build reports, basically give you a place to sort of collaborate and put all of your work together. So what are we going to cover today? So this is a quick breakdown of what we're going to cover. We only have about 45 minutes or so for these presentations, so we're not going to cover absolutely everything there is to know about this topic because there's a lot to this. It's a complex subject, but I'm going to try to hit some of the high points, try to cover some things that I've seen when I talk to other labs. I talk to other experts in the field about their experiences and testimony and dealing with opposing experts and drawing from my own experience. We're going to try to cover some of these high points that I think are really important for people to know. This is mostly going to be for the digital forensics experts in the audience. If there are any attorneys, prosecutors, investigators in here as well, this could be useful to know just to see how we look at things from our perspective as the expert and things that you can think about when you're working with your experts in terms of, how to address, a potential opposition and potentially putting together a strategy. So what we're going to do is we're going to define the experts. And what that means is we're going to talk about, who are all the players in terms of the expertise in these cases, and what are their roles, what are their objectives, that sort of thing. We're going to cover some differences between criminal and civil cases. For the most part, the forensics being done is the same, but how we present that information, how we address that information in court is a little bit different. And some of the strategies we have available to us are a little bit different depending on whether we're working in a criminal case or a civil case. We're going to discuss a little bit about who has the advantage in these cases. So whether you're in a civil litigation or a criminal case, we're going to talk about which experts have the basic advantage in these cases. And I'm going to explain why I have that view on it and why I have that opinion. We're also going to cover multiple things about, what you should expect, whether you're, working for the plaintiff. Basically in courts we can divide things into offense and defense, right? So whether you're working on behalf of the offense or the defense, we're going to talk about some things to expect from someone that's generally going to be opposing you as an expert. We're also going to talk about some strategies on how we should prepare, like how should we prepare ourselves and prepare the evidence we're working with to basically be put in front of another expert that's going to review everything. And then finally, like this isn't really a specific section, but throughout all these different areas, I'm going to bring up multiple case examples from my own career to try to exemplify what we're talking about. Like what are the things that, how does this materialize in reality in terms of these different concepts? So let's define our players. So for criminal cases, and this is probably just a review for most people on here, this isn't anything new or special, but we're going to have our prosecution experts and we're going to have our defense experts, right? And I put together some basic definitions of what these roles are and what they're generally doing. And if I read these out, you're going to notice they're very similar. There's only some small differences here. So for state's experts, collect and analyze evidence to support the investigation and prosecution of individuals suspected of committing violations of law. For defense experts, it's almost exactly the same. The only difference is it's just the different side that we're working on, right? So collect and analyze evidence in support of the defense of individuals suspected of committing violations of law. That's really the only difference at the end of the day. Generally, prosecution experts are going to use their expertise to provide consultation to the prosecutors and investigators in the case. Same thing for defense experts. They're going to provide expert consultation to defense counsel and defendants with respect to the digital evidence. So when we really break these parts down to their basic functions, they're very, very similar. It's just who their end client is really the main difference here. So that's something that's really important to think about in criminal cases. Now, if we look at civil litigation, we'll notice again, this is almost exactly the same thing. And if you'll notice, I put these two slides together on purpose because I wanted to show that realistically, what we're all doing, whether we're working on defense or working for the offense, plaintiff and prosecution, the basic core functions of what we're doing as experts is the same. We're collecting, we're analyzing evidence, and we're doing it in support of whoever our client is, right? The client is giving us case details. They're asking us for our expertise on how do we work through this evidence, what evidence is important, what does this evidence mean, how do we use it in the case, what do we do with this evidence, how impactful is it, that sort of thing. So no matter if we're doing this on the criminal side or the civil side, largely what our work is mostly the same. It's just typically who our end clients are that really matter. So what are for us as experts, what are some of the major differences in these cases that we really need to be thinking about? So one is going to be our burden of proof standards. So in criminal cases, we have the beyond a reasonable doubt. In civil cases, we have preponderance of the evidence. So that typically means that we are required to present a lot more evidence in a criminal case than we would a civil case to achieve different outcomes. So that affects how we look at evidence. It affects how we think about the evidence. It affects how we talk to our clients, whether it's a prosecutor or a civil litigator, right? We think about this evidence differently. We think about how impactful it is differently. And those are the main differences in these types of cases for our proof standards. For discovery is also quite a bit different in these different types of cases. Typically, and again, these are broad strokes that we're painting here. We're not going into all the different nuances, but we're just typically making overall, assessments of the differences here. Evidence discovery in criminal cases are more or less the defense gets just about everything, gets access to anything they need in terms of what. There is some exceptions to that, but for the most part, if there's a laptop that evidence is being presented by the prosecution, the defense generally is going to get access to that laptop and that forensic image. To do our own independent analysis, we're going to look at that, and that's how that discovery is generally going to be expected to work in criminal cases. Civil cases are much more complex. In civil cases, we don't necessarily, whether you're defense or plaintiff, we don't just automatically get access to every single bit of evidence that the other side has. The answer typically is like we do get access to it in terms of what's being presented, but that just because they present some information about a laptop in a civil case doesn't mean that we automatically get the full forensic image of that laptop. Typically, there's a discovery process in civil cases where we're going to go through privilege review, we're going to go through filtering, we're going to go through a bunch of different processes to make sure that basically everybody's data is protected, and that we're not seeing more data than is necessary to work on the case. So in civil cases, that can present sometimes a challenge when, if we're trying to assess an opposing expert's view on a case, we can be more limited in how much access we have to the evidence, and we may even have to make arguments about why we need more access than what the other side is comfortable with giving us. And sometimes we have to convince a judge that that's necessary. So there's stuff in discovery that's really different between these two types of cases. The next thing to think about too is what are our pretrial actions and strategy, going into a trial or a hearing, that sort of thing. In civil cases, and again, we're not talking about the nuances, we're talking about the broad strokes here, but in civil cases, we have things like depositions, interrogatories, forensic protocols, and all these other different actions that we can take to try to get a lot more information before we head into a trial or a hearing. Depositions, for one, can be extremely useful when we're deposing an opposing expert. By the time we do a deposition of them, we usually have, discussed with the attorney all the different nuances of their analysis, all the different nuances of the case, so that we can be, help the attorney prepare questions. And in some cases that I've been on, I've actually been allowed to be in the deposition so I can assist the attorney with asking those questions and dealing with answers that they're given. I've even done it remotely where we've been in a deposition and I've had a chat window where I could discuss with the attorney as I see questions being answered, and then we could help them with the overall deposition process. But the purpose of the deposition is that, we get to ask that opposing expert all kinds of questions about, usually within reason, a lot of different questions about their analysis, about themselves, about the work they did, about their processes. The idea is to get as much information as we can so that the litigator can filter that down into the important pieces that then can be used at the hearing or the trial coming up. Same with interrogatories. Interrogatories are more like formal requests for information that gets sent to the other side, and then they respond in kind. Forensic protocols, these are usually what come into play during the discovery process, where we are able to put together, if we want to access certain kinds of information or evidence that they have, or vice versa, and our clients are worried about the level of access or data that they're going to get, we can put together these forensic protocols that basically outline the process of, here's how we're going to collect and process and analyze and produce this data. And that forensic protocol is something that we put together and then both sides agree to, and then the forensic experts carry out that protocol to execute that discovery, that piece of discovery for the case. And that's a really nice way for us to sort of kind of grease the wheels on sharing data in cases where the two sides are a little apprehensive about sharing too much information. In criminal cases, our actions are a little bit more limited. We don't have in most cases, we don't have depositions. We don't have, all these nice tool sets that we can use beforehand before we get to a trial or hearing or whatever. But the opposite end is that we usually get a lot more access to the evidence. So typically we're, going to be, if there's 100 items that were seized in a case for for defense experts, they're typically going to get access to that evidence if they need to, even if it means coming on site to do the review, that sort of thing. So we don't have things like, we can't necessarily depose the other side's experts, but we do get access to, usually get access to most of the evidence that we want. So it makes it to where we have a much broader, basically a much more broader plane of work that we can do with that evidence. So if we think about our cases when we're dealing with opposing experts, is there an inherent advantage somewhere? Is there, which side has the advantage just from an expert point of view? Not necessarily from the overall case. The overall case can have its own problems and nuances that may make one case more difficult for one side, depending on just the details of the case. But in terms of us as experts, who really has the advantage? And one way I like to kind of break this down is we think about something like poker. Poker is a hobby of mine. I'm like okay at it. I'm not great, but I'm okay. But one of the big deals in poker is position is a huge part of the strategy of the game. And what I have here is a poker table that sort of lays out sort of all the positions in a typical 9-handed game where you have 9 players and you have all these different positions, starting with under the gun, earliest position, under the gun +1, +2, low jack, high jack, cutoff, and the button, and then you have the blinds, right? So in a round of poker, the first person to make an action is going to be under the gun, and then the last person is typically going to be the person sitting on the dealer button. Now, the reason that the dealer button is so important is because that person gets to act after everybody else does. So what that means is every round that you're on the dealer button, you get access to more information than everybody else does before anybody, everybody else has taken some kind of action and giving you information about what their cards are. So when you're on the button, you by default are the most intelligent player on the table at that moment, because nobody else knows what you're going to do. Nobody else has any idea what kind of hand you have, but you have an idea of what everybody else has. So if we have our under the gun player, if he makes a huge raise, then we know that he must be pretty strong, right? Because he's advertising to everybody else behind him, I've got a really good hand here. So I'm going to put a lot of money on this hand, and I'm not too worried about what everybody else has. So by the time it gets to us, we know, okay, we better have a pretty strong hand if we want to fight against this person. But if we were sitting, under the gun and we had something like a good hand but not strong hand, we'd be in a really, really bad position because we have all these other people to act after us and we don't know what they have. So the point I'm trying to illustrate here is that typically the positional advantage here is whoever goes last has the most information. So how does that translate into our casework when we're working with opposing experts? Basically, defense experts act last. So whether you're in a civil case or a criminal case, defense experts have a bit of an inherent advantage, meaning that they get to see everything before they make a move, right? They get to see, what have you reported on? What is your analysis? What are you claiming? What accusations are being made? What is the evidence you're using to base those accusations on? The defense expert gets to see all that stuff before they make their first move, right? So in a game theory situation and in a positional play situation, they have that inherent advantage every single time. This does not matter if it's a civil case or a criminal case. As a plaintiff's or state's expert, you basically started nothing except for the case background, right? So if you're working for law enforcement, you have a case agent or investigator that brings you a case. They bring you a phone or some computers or something. They give you some basic background and they ask you, hey, can you please process this? And that usually means you're going to go through your normal processing procedure, do whatever it is you do, give the case agent some information. If you do a more, high-level analysis, you may produce some kind of forensic report with a full narrative that explains your opinions and narrative and evidence that you're basing that on and things like that. But the point is that defense expert that works for defense counsel or whether it's civil or criminal, they're going to see all of that information and be able to use that to their advantage to make their next decisions, because they're going to know how strong is your evidence. They're going to know, okay, all I have to worry about are these pieces of evidence, these pieces of information. I don't have to, as a defense expert or opposing expert, I don't have to dig through everything on the computer. All I have to do is focus on the things that you're saying, right? I don't have to worry about the entire universe of everything. I just have to focus on, here are the things that you're claiming, and then I can focus on those and try to mitigate or disprove or show that those items aren't as impactful as you think they are, if possible, of course. Right. And again, I want to reiterate, this is not an overall case advantage. Just because the defense experts have this inherent advantage, it doesn't mean that the defense case overall has the inherent advantage. Like I said, every case is different. They each have their own nuances. Some cases are stronger than others. That is much more dependent on all these other factors outside the expert. But in general, when it just comes down to, in general, every case without looking at any evidence yet, the defense, again, either both civil and criminal, is going to have this inherent positional advantage. And that's something you really internalize and think about in terms of when you're putting your evidence together, you're putting your case together, you're trying to define, how do we want to approach this evidence? How do we want to present this information to the court? knowing that somebody is going to have this advantage of seeing everything we do before they decide what to do next. So what should we expect when we're getting ready to deal with an opposing expert? As stated earlier, the objectives of each expert, depending on which side you're on, are going to depend on whether you're defense or offense. Again, if you're offense, you're basically trying to find evidence that supports the prosecution or claim against the defense. If you're in the defense, then your objective is generally going to be, is there evidence to refute what's being accused or being said, or is there evidence to mitigate it? So a competent expert, if you're dealing with a competent opposing expert, they are going to want to analyze and see the same data that you looked at, or as closely as they can. Meaning that if you've produced a Cellebrite UFED report, for example, and you gave that to a prosecutor, a competent expert is not going to want to see that report. They don't care about whatever the end product was necessarily that you gave them, other than your general narrative. They're not going to care about, okay, you produced an Axiom report or a Cellebrite report. No competent expert cares about that. What they care about is, what have you had to say about the evidence? What is the argument being made about the evidence in the charging document, or what is the claim being made in the plaintiff's motion? That's the stuff that we care about. We're going to look at what is the evidence that the other side cares about, and what are the claims about the evidence that they're making. And in order to do that, the opposing expert wants to see the same data that you're looking at, because they want to know that we're looking at the same stuff they are, so that we can assess our own opinions and assess our own evidence, that sort of thing. Something to keep in mind too is a good expert will sometimes reach out. I've done this multiple times on cases, in both civil and criminal cases, where if the other side has some information, or if I want some clarity on things that they're stating or have information about, I will just straight up reach out to the other expert and ask questions. I'll usually confer with our client about it first, and let them give them a heads up, saying, hey, I want to talk to this expert. I have a few questions. I want to see if they can help me understand a couple things. That's perfectly fine. There's no problem with that as far as I know. Again, the other expert has to agree to it. They may not. That's fine. But it's not a bad idea. We're experts. We're professionals. We're not enemies. We're just trying to get our jobs done. We're just trying to, provide the best consultation we can to our clients. And part of this is doing that. Good experts will also likely review documentation, not just the evidence. So we'll look at search warrants, we're going to look at affidavits, we'll look at motion filings, we'll read the main complaint from the plaintiff. We're going to look at all of the context surrounding the evidence to have a good understanding of, what is the general case, and what is the weight of this evidence overall? What does it mean to the other side? Is this evidence as strong as they say it is? Things like that. We're looking just to understand, what is the other side saying about this evidence? What is the importance of it? Because just saying the evidence is there isn't quite good enough. We want to know, how important is this evidence to you? So I have a couple of case examples I'll quickly go through to talk about this. And so I have this one called "They Deleted the Evidence." And what that basically means is that it goes to the competent expert will want to see and analyze the same data you based your analysis on. This was several years ago. It was a child pornography case. Basically, the agency had a device, a phone that they had found a couple of images on, a couple of contraband images on, and basically the entire job was, an attorney asked me to just go take a trip to the police agency and just take a look at the evidence and make sure it is what they said it was. That's a big piece of doing defense work, is you're really just verifying that the evidence is what's being claimed. So basically, I get there, and this is an old Galaxy S5, I think. This was several years ago, so it was before we could even do full physical extractions of those devices. I arrive, and when I got there, they were doing a new extraction for some reason, which was not a big deal to me at the time. But once I loaded the new extraction, I was not able to find the offending images that they had identified in their report. Their report had identified what the images were and where they were located, but when I looked at the phone, they were no longer there. The images were just gone. So I asked the the analyst was like, okay, well, where's the evidence that you looked at? Like, where's the original evidence that you collected that has the child pornography images in it, the CSAM? And basically, they told me they didn't have it anymore. Apparently, they had removed the evidence in order to. It looks like they did it because they just ran out of space or something on their storage array. So they made a habit of deleting some of this evidence, and they thought, well, we'll just recollect it from the phone if we need to. The problem is that the data they were looking at apparently was some kind of volatile information or something, and the evidence just wasn't there anymore. So what ended up happening was I reported this to the defense attorney, who then had a conversation with the prosecutor, who subsequently dropped the charges. So a situation like that's just where if all I looked at was, if as the opposing expert, if all I looked at was the report that they generated, this is something that would have never come up, potentially, unless it went to trial or something. So this is something that competent experts are going to want to do. They're just going to want to look at the same evidence that you looked at, even if that means we need to take a trip to your office. If it's a criminal case, in some cases we may have to just look at the evidence on site, which is fine. If it's a civil case, same thing. We're going to want to look at the same evidence that everybody else does to the reasonable extent we can. Another case example is going to be, I labeled it, they only imaged half the device. So what this is a situation with another entity had conducted a chip off on a phone. They created a forensic image of that chip. I got a copy of the forensic image, started looking at it, immediately noticed there was something wrong with it. What it turns out was that the forensic image I was given, the process they used to image the chip had basically stopped halfway through. So the image they generated was only half of, it was a maybe 32 gigabyte chip, and it only imaged about 16 gigabytes and stopped. It had to do with a flaw in the chip imaging software that they were using. But that's the reason I bring this up, is because when I saw this issue, again, this is several years ago, but when I noticed this issue, I pulled the image up in X-Ways and immediately saw there was a problem with the data. We could still read the file system, but basically half of the data wasn't there. What I did was I reached out to the other expert. I just called them up and I had a conversation with them and asked them to try to understand what was going on. Like maybe the image got corrupted on the copy or something along those lines. And I was able to, basically we were able to help that expert figure out what had happened, because they just weren't aware that the image had this problem. So in order to rectify it, I just asked them, hey, send us the original chip. We have some additional chip imaging equipment we can use. We can see if we can get the full image, and sure enough, we were able to do that. They sent us the original chip that they pulled. We used our hardware to do the image, and we got the full image. So things like that can be, it was an honest mistake on their part. It wasn't something, it could have been resolved through some kind of peer review or QA process, but it wasn't something they did on purpose. It was just a happenstance of their equipment failing on them, and they didn't realize it. So things like this are helpful when you reach out to those other experts to try to resolve these issues, because at the end of the day, this was a mistake, but it didn't materially change the evidence, because the evidence was still on the chip. Having half the chip missing, chip image missing, didn't actually change any of the evidence. But by being able to resolve this issue, it just made the case a little bit easier to progress through. But that's why we leave ourselves open to talking to these opposing experts to make sure we can make an honest effort to clear up issues like this. Okay, so what, in terms of your findings, what should you be expecting? So one of the things opposing experts should be looking at, first and foremost, they're just going to determine the accuracy of your findings. What that means is that if you say that there's evidence of a crime or evidence of some kind of violation of the law related to a civil litigation or something like that, or violation of contract, whatever the case may be, we're just going to review the evidence you're referencing, and we're going to determine whether that's accurate or not. And that just means if you say this link file exists with a certain timestamp, we're going to look for that link file and verify that you're right. That timestamp is what you say it is, right? The opinion piece hasn't even come into this yet. Just looking at the raw data and making sure that all the specific pieces of trace evidence and artifacts are as accurate as you're claiming them to be. We're going to look at, are we seeing the same evidence? Are we seeing the same details that you are? Is there anything that doesn't look right to us based on your interpretation or reporting of the evidence? This could be things like, I have another case that I'll talk about in a moment, but that exemplifies this, where I looked at evidence and it did not match up at all with what their reporting was saying. There was a discrepancy that I needed to figure out. Are the stated artifacts present as described, like I said, with a link file or shell bag artifacts? Are these items actually there? Do they actually exist on this device as described? Are there any alternate explanations supported by the evidence? So what that means is, if you have a report that claims that the evidence indicates a certain action or a certain circumstance around the accused person, or vice versa, if you're on defense, you may claim something about an action the user took that's beneficial to the defense, right? We're going to look at, well, is that the only explanation that's supported by the evidence? And supported by the evidence is a big important piece, because you can come up with a lot of alternate explanations for different different actions for forensic artifacts. They're not all going to be supported by the evidence, right? So supported by the evidence literally means, in forensics, there are some cases where you can look at a forensic artifact and there may be one or two explanations for how that artifact ended up the way it ended up, right? So that's what we're going to look for, is like, okay, well, you wrote up this report and you tunnel visioned into a very specific explanation, but there's actually 2 or 3 other reasons why this evidence could end up the way it has. And because you're working for one particular side, whether it's defense or the offense, you've tunnel visioned into this very specific explanation. So part of the opposing is they're going to come up with these alternate explanations. Again, these should be supported by the evidence, right? We can't, for a good example is, an alternative explanation to someone copying a file to the thumb drive is that aliens did it, right? Oh, well, aliens did this, clearly. I mean, that's an alternate explanation, but there's literally no evidence to support that, none whatsoever. So it's not a good alternative explanation. A good alternative explanation is going to be just as much based on the evidence as the original explanation is, and they're going to be equally weighted against each other. That's why it's a good alternate explanation. So a case example of this is, this is a case I worked on several years ago. Again, it was a civil litigation where plaintiff's side accused a former employee of deleting their Windows account before leaving the company. And basically what I ended up working on and figuring out was, this wasn't the user that deleted it. It was a misconfiguration by the company's IT department. They basically screwed up configuring this guy's laptop, and they sent it out to him, and the laptop was stuck in this weird mode of, every time he shut down the computer, it would delete his Windows profile and create a default temporary profile for him. And it was just stuck in this constant loop every time. And every time he did this, they had a Windows management system that would completely install all of his new software, and basically it was like working with a new computer every time he turned it on. Now, the reason I bring this case up is because this was a fairly large consulting company that did this work, that put together this huge report about how this Windows account was deleted. But there was a couple of things that, when I looked at it, I had problems with. One was, they didn't have any actual evidence of the account being deleted. Like, there was no evidence that said user deleted this thing. It wasn't like the user profile was in the recycle bin or something. There weren't any event logs showing that, there wasn't anything they were pointing to that said it was the user deleting it. They just said the user profile wasn't there, so therefore he must have deleted it, right? So in that case, when I look at the case, I say, well, I don't see the same evidence they do. They're claiming all of this evidence, but I don't see that here. So I'm going to take a more critical look and see if I can figure out what's going on here. And it's like, maybe they're right and there just isn't any evidence of it, but as another expert, to me, they haven't closed that loop yet. They haven't bridged the gap between user action and the state of the evidence to say the user is responsible for this adverse position of the evidence. So what I ended up doing was spending a lot of time just looking through a lot of the data on the computer, talk to the company, try to understand how their IT process works. And really what made the case was looking through event logs, and found some really obscure Windows logs that basically just logged that the system was set up in this weird loop where every time the user shut down the computer, it would destroy the profile and then create a new profile in its place when it started back up again. And it was literally a user profile and account called default. So, and we were able to go through IT records and basically show that ever since this laptop was even shipped to the employee, it was always in that state. So the employee never actually had a legitimate, persistent profile on this computer. And the reason this is so important is because that other side, they had a lot of people working on this case, and they just got so excited about finding something that they could, pin their case on, that they didn't actually think about what they found critically. They didn't take a critical look and think about, does this actually make sense? Does this, just because we see this on the computer, doesn't necessarily mean, it doesn't lead to our conclusion that the user did something to cause it. This is a very unique situation that I'd never seen before in a case. I'd never seen a Windows system do this before. And the other side should have been aware of that as well. They should have looked at it and said, we've actually never seen this before. My first thought was, I don't think this is even possible. I don't think it's possible for a user to just delete their user profile without having full admin access to the computer, which this person did not have. So there are a few critical components there that they missed, but the point is, we weren't looking at the same evidence. I wasn't seeing the same evidence. I did not see this evidence that a user affirmatively deleted this profile. So that's what I'm trying to explain with this case. So another thing that opposing experts are going to look at, and we've kind of alluded to this a little bit already, but we're looking for mitigating or exculpatory evidence. So the big one is just straight up exculpatory evidence, right? One side says, hey, there's forensic evidence that shows this person did this thing. Well, if we find we might find some additional evidence on that same computer or on a different device altogether that completely refutes that. And just something that says, like, it's not possible for the person to have done this and also be responsible for this other thing, or there's this other thing that shows that this action you're alluding to is some automated process that the user had no control over, right? So that would kind of tie back into this other case about the deleted user's account. We basically found exculpatory evidence. We found things like an email and event logs that basically exonerated this person from this issue, right? So this was so strong that it was just straight up, we showed this guy didn't do what they were accused of. Mitigating evidence is more like, okay, these things did happen, and maybe the user was responsible for it, but here are the other things surrounding that evidence that makes more sense of why this happened. We find additional forensic evidence that shows, like, okay, well, this was also a part of some other process that they went through that caused this action to occur. And this ties in usually into when we start talking about the intent of the user, where if the prosecutors, defense attorneys, the civil litigators, they want us to figure out, if the lawyers are smart enough to know that, look, this evidence only matters if the intent of the person was malicious. Otherwise, if we can show that it wasn't malicious, if it was just some routine process that occurs, then that can help us mitigate how important this evidence actually is. So that's something that we'll look for. We'll look at, okay, person we have this evidence of something that's going to hurt our client, and our client's asking us to look for any evidence that helps relieve the pressure of that accusation in terms of what this evidence means. So that's what we're looking for when we say mitigating evidence. And then something to think in mind too is, earlier we talked about our burden of proof. So this is one of those times where that burden of proof standard comes into play. There is no 100% proof standard. So in civil cases or criminal cases, the standard is not 100% absolute proof that a person did the thing we say they did. So what that means is that you can have beyond a reasonable doubt standards met with evidence. You can have preponderance of the evidence met. That does not mean that the person actually conducted the act they're being accused of. It just means we have enough evidence to meet the standards that our courts system says we need to move forward with a conviction or move forward with a judgment in a plaintiff case or whatever. So what that means is that as we're thinking about that from, if we're on offense and we're thinking about these burden of proof standards, it's something we need to keep in mind, is that even though we may have met that burden of proof, it doesn't necessarily mean that it's 100% correct. And that's where thinking about things critically comes into play when you're trying to anticipate an opposing expert. because a good opposing expert is going to understand this. They're going to understand the logic behind burden of proof standards and understand that just because we've met preponderance or met burden of proof based on what we're seeing so far, it doesn't mean that there isn't additional evidence that can remove that reasonable doubt, that can add reasonable doubt, or that can remove that preponderance, right? That more than likely that something occurred, right? We just know that this is the evidence you have, and we're going to see if we can change the impact of that evidence, which would affect the burden of proof that you think you currently have. So hopefully that makes sense. That's a kind of a logic, sort of a logic bomb there to think about, but it's how, if I'm looking at, as an opposing expert, if I'm looking at evidence, this is how I'm looking at the evidence. So I'm thinking, okay, they've got this evidence, it looks bad, but let's take a look and see if there's anything that changes the interpretation of that evidence that affects what they think their current, that affects whether they think they've met that burden of proof or not. Finally here, do they agree with your opinions? So, we may all agree that the evidence is correct, that the evidence in the forensic artifacts you're referencing is correct, but do we agree with your interpretation of it? Whether, again, this does not matter if you're defense or offense. It really matters if I'm on defense and I make a claim about evidence that says certain things happen, do you agree with that? Like, you can agree that the evidence is correct, that yeah, that link file has a creation timestamp of this or whatever, but does that mean that I agree with your ultimate conclusion as to what that timestamp represents? So this gets into something I want to talk about, which is, talking about what our expert opinions are in digital forensics, because this is something that, even with my company, with Monolith, I talk to a lot of forensic analysts in both the public and private sectors, and this is something that I see a lot that I'd like to address, which is, let's talk about what your expert opinion is. So typically, we're dealing with things like fact witnesses versus expert witnesses. An example here is, a non-expert opinion is something like, mushrooms are terrible and should never be eaten. I personally don't like mushrooms, and this is my view on mushrooms. Like, they're awful. You should never eat them. It shouldn't be a part of anything. It ruins any dish they're in. So it just shouldn't be a part of food, right, in my opinion. But that's my personal opinion. I'm not an expert on mushrooms. I'm not an expert on food, really. This is just my personal opinion that really has no authority or weight that anyone should take seriously. Below is an expert opinion, right? So here we're saying the creation time of the shell link file indicates that the file was first opened by user XYZ at that date and time. That is an expert opinion that we can all agree that, yes, that's correct. There is a shell link file, and yes, it does have a creation timestamp of that, and it is associated with this user profile. Those are all facts that we as experts can agree on. But once we start making determinations about what those facts mean and how they affect a user, or how they what they represent for actions that have occurred in the past, those are our expert opinions. And once we get, and the reason I'm bringing this up is I talk to a lot of folks that they have this attitude that digital forensics is just a bunch of zeros and ones. They don't like to call it an opinion because that means it could possibly be wrong. Well, you're right, it is a bunch of zeros and ones, but the main difference is that when you walk into a courtroom, nobody else in that courtroom can say these things about the evidence. Only you can. Like, for example, we have this fact witness. If we printed out a sheet of paper that had some information about a link file, sure, we can hand that to a judge or a jurist, and they can read it and say, yeah, this piece of paper says that a file called file.lnk has a creation timestamp of whatever, right? That's a fact witness. They're just reading from a document and saying, yeah, this has English words on it that I can read, right? But they can't tell you anything about what that information actually means. What does that mean for the context of the case? What does that mean for our defendant or our plaintiff or whatever the case may be? That's what your expert opinion is you have special knowledge, skills, and expertise and training where you can walk in and give that insight and interpretation to the court that nobody else can do. That's what makes you an expert. So you shouldn't sell yourself short. And I hope everybody can see the difference here between this mushroom statement and this expert opinion. These aren't necessarily what we would call purely personal opinions. These are based on the same set of knowledge and rules that we all work with as digital forensics experts to come to this interpretation. In this right here, I just I just already said this stuff. So this is just kind of repeating that. And I do have an example of this. So if anyone hasn't, hopefully everybody's seen this movie, but there's a movie called My Cousin Vinny. It has an amazing section of the movie where a person, Marissa Tomei, testifies as an expert. And this text right here, this transcript, is basically the voir dire process where the prosecutor tries to disqualify her as an expert in the area of automobile mechanics. Okay, and we can see here that Vincent is claiming she's an expert, and he's inviting the prosecutor to challenge her. And basically what he gets to is he asks her a question about the timing, the ignition timing on a very specific vehicle, and she says, no, this is bullshit, this isn't even possible. And basically he's accusing her because she doesn't know what the answer is. What it gets down to is she does know the answer, but she knows it so well that the prosecutor had the initial information wrong about the vehicle he was asking about. So she corrects him and says, no, you're thinking of the 64 model, which had this ignition timing of this particular setting. And then the prosecutor, basically accepts and says, okay, yeah, she's an expert. She obviously knows this stuff. So keep in mind, we could pull the manual or the automotive manufacturer information about this vehicle and confirm this information, right? Because these should technically be facts, right? But the point is that no one else in the courtroom could articulate these facts and interpret them the way we need to. And this is part of her qualification, but we have a video here. We're going to show the actual testimony that she gives based on that qualification. So we can see what that result is of what that expert opinion and knowledge looks like.
3 Pontiac Tempest.
Objection, Your Honor. Can we clarify to the court whether the witness is stating opinion or fact?
This is your opinion?
It's a fact.
I find it hard to believe that this kind of information could be ascertained simply by looking at a picture.
Would you like me to explain?
I would love to hear this.
So would I.
The car that made these 2 equal-length tire marks had positive traction. Can't make those marks without positive traction, which was not available on the 64 Buick Skylark.
And why not? What is positive traction?
It's a limited slip differential which distributes power equally to both the right and left tires. The 64 Skylark had a regular differential, which anyone who's been stuck in the mud in Alabama knows. You step on the gas, one tire spins, the other tire does nothing.
That's right.
Is that it?
No, there's more. You see, when the left tire mark goes up on the curb and the right tire mark stays flat and even, well, the 64 Skylark had a solid rear axle. So when the left tire would go up on the curb, the right tire would tilt out and ride along its edge. But that didn't happen here. The tire mark stayed flat and even. This car had an independent rear suspension. Now, in the 60s, there were only 2 other cars made in America that had positive traction and independent rear suspension and enough power to make these marks. One was the Corvette, which could never be confused with the Buick Skylark. The other had the same body length, height, width, weight, wheelbase, and wheel track as the 64 Skylark, and that was the 1963 Pontiac Tempest.
And because both cars were made by GM, were both cars available in metallic mint green paint?
They were.
Thank you, Ms. Vito. No more questions. Thank you very, very much. You've been a lovely, lovely witness.
Okay, so hopefully that demonstrates what I'm talking about. So in that testimony, she provided lots of factual information that she knew just from her experience, and she also added a lot of interpretation to those facts, right? So she added a lot of things about what that evidence could possibly mean, tying the tire tread marks with her knowledge and facts about different manufacturer vehicles, and then put all that information into an interpretation that she could explain to the court in terms of, this is why this is important, this is why you should care, this is how it affects the case. That's what makes her opinions, what she's saying, an expert opinion, because she's not just reading off some random facts about these different vehicles. She's providing an interpretation of those facts, which is what we do when we testify as digital forensics experts. Instead of talking about cars, we're talking about computer forensic evidence, and we're using that to to basically give our opinions on what that evidence means and provide a story of events to the court. So we're on our last leg here. We'll finish up here in the next couple of minutes, but you know, last bit of what you should expect, you know, opposing experts are going to look for new evidence. So part of the exculpatory and mitigation process, they're going to look for new evidence that you haven't looked at. You know, people are really smart. They may think of things that you haven't. There may be other evidence sources you're not aware of that they're going to go after and try to find. They will probably also, if sometimes there's evidence that you couldn't do anything with, whether you couldn't crack the passcode on it or the device appeared to not be working to you and you just couldn't power it on, couldn't get any data from it. Part of the discovery process, the opposing expert's going to say, well, I want to take a look at that. I want to see if we can do anything with it. And that's perfectly fine because maybe they can't. And in fact, I have an example of that. So several years ago, again, had another case where, you know, a person's being accused of something and one of the witnesses involved had an iPhone that the original examiners working on the case, the iPhone had a really broken screen and just clearly looked like it was just broken, and they just didn't bother doing anything with it. They didn't try, they couldn't get it to turn on, and they just kind of, you just didn't do anything with it. So this was a case that was, it was actually a military case, and the investigator assigned to the military defense reached out to the company I was working with at the time and really just asked us, hey, can you work on this phone, see if you can get any data off of it? So they sent us the phone, and this was a case where I really didn't dive that deep into it. I didn't really know a whole lot about it. The only objective here was really just see if we can get the phone working and get you know, data off of it. So I received the iPhone, and really I didn't do anything special. We just replaced the screen. That's it. We just took the broken screen off, put a new one on it, and the phone booted up just fine. You know, we charged a little bit and then extracted the data. And I really didn't do anything special. We just sent back a Celebrite report with all the content. And then later on, I realized, talking to that investigator, he told me that the evidence, the text messages that they had pulled from that iPhone basically exonerated the person being accused of something. And that's a situation where, you know, a good opposing expert should be looking at opportunities like this. Like, we should be looking for, is there evidence that the other side couldn't process or the other side couldn't work on? So if you have evidence that you've collected that you weren't able to do anything with, that's something to keep your eye on, right? Is like, okay, well, we couldn't do anything with this. Maybe I should ask around and really talk to other experts and make sure we've done everything we can with this thing and make sure that there's nothing more that we can do with it. This is another opportunity to have a conversation with the other expert. If you're the opposing side and, you know, if the other side says, yeah, we have this phone, but it's broken, doesn't appear to be working, then we'll, you know, we'll try to deal, you know, is there something we can do with it and can we deal with that? So how should you prepare? So you want to validate your findings. So what this means is, in this industry, we talk a lot about validating tools, but that's not really, it's a sort of old school way of thinking about it, and it's not very realistic for a lot of reasons. Tool manufacturers can push out hot fixes and patches constantly, and there's no way you can keep up with validating them. But what you can keep up with is validating your key findings. So that just means that we're going to isolate the bits of evidence that we've collected that are actually important to the case and do an extra round of validation to make sure that those are correct. And I did have a case example here, but I'm running out of time, so I'm going to skip that for now to get to the next slide. So this is a common process that we see, especially if you're in law enforcement. This is a very common process that we'll see, is you extract the data, create some kind of Celebrite dump or report, provide it to your client, which is typically a prosecutor or investigator. Months pass, and then suddenly you're in court testifying, where you haven't really talked to the prosecutor about this stuff. Hopefully you have, but a lot of times you don't, and you just end up testifying about stuff and you have no idea what the prosecutor is really going to ask about. And a lot of times they bring up information that hasn't been cleared by you yet. So sometimes they can make, I've seen this before, where they can make really bad arguments about information that they see in the report that you've given them without really conferring with you first. Whereas a suggested process, which admittedly takes a little bit more time and effort, but you should create your report, whether it be Celebrite Access or whatever the case may be that you're giving them, And then once it's provided to the client, you want to collaborate on relevant evidence, validate those items. Time passes, you're getting ready to court, and you're going to review those findings again with your client, with the prosecutor or the plaintiff or whatever the case may be. And this middle section here is what's really important, because that investigator or prosecutor can look at all this evidence that you don't really have all the context for, and they can identify the stuff that they care about. They can find the text messages that matter to them, the web history hits that matter to them, all of that stuff. And what your job is then to come back to them and say, okay, what did you find, and what did you find that's important? What are you going to put in your charging document? What are you going to put in your plaintiff motion or whatever based on this evidence? And give me a chance to make sure that stuff is accurate. Because if you handed them a report with 10,000 web history hits and they pick out 2 or 3 that are actually important to them, it's worth spending 10 minutes digging into that web history database, whether it's Google Chrome or Firefox or whatever, and just manually validating those 3 records just to make sure that the tool got it right. Just to make sure the information is what you think it is. Especially if, it's really important, especially in criminal cases where if you have, real victims that have been affected by this case, you don't want this to be the reason why the case goes bad or goes sour. It's worth spending the extra 30, 45 minutes to an hour to just take a second look at the key elements of the evidence that you're going to be worried about in court. It's worth to spend that time on it. Lastly, have a solid quality assurance process. So if you can, you want to have your work reviewed by another expert. This means they should be looking at the raw evidence, making sure everything was collected properly. They should, quickly load these things into forensic tools to make sure everything parses properly. Look at your analysis, make sure that you looked at all the necessary evidence. They may even reconduct some of the analysis just to make sure that they see the same things you do. And basically you want this other expert to review it that's on your team to act as that opposing expert. You want them to have that critical eye with really knowing as little about the case as possible, just looking at your evidence and making sure that they see the same things you do and provide you with any other alternative ways of looking at it. And I put a quick metric to here to think about. So if you work on 300 evidence items a year, let's say you have an error rate of 0.5%. Which sounds like pretty damn small. But if you blow that up to 300 evidence items, that means that there's a problem with 1 to 2 of your evidence items every year. So the way we try to mitigate this and make this error rate as small as possible is by having the sort of validating your findings and having another expert do some kind of review of the evidence and the results that you're trying to present. Because we want this error rate to be as small as possible to make sure we don't run into problems once we hand this over to an opposing expert or walk into court with it. Lastly, don't take these things personally. No matter what side of the case you're working on, plaintiff, criminal, defense, whatever the case may be, most experts that do this are just trying to give good, honest consultation to their clients. That means they're going to be critical of the work you've done. They're going to make no assumptions about your accuracy or about how good you are at this work until they've confirmed the results themselves. Expect every single case to have an opposing expert. This way, you're never worried, you're never surprised or anxious about it. It's just what you've come to expect. It's just a part of the job. It's just a part of how this works. So the point is, don't let your blood pressure go up because of this stuff. Don't take it personally. These guys, for the most part, these opposing experts that are against you or whatever, they're just trying to give their client good consultation. And then lastly, sometimes this stuff is just out of your control. There are some bad experts out there. You've got hired guns, you've got incompetent experts that are like, oh, my friend is an IT expert or something that knows nothing about forensics, but they ask them for help anyway. You've got some people that are, if you testify enough, you'll run into these people that are like experts in everything. They're experts in forensics, they're experts in camera surveillance, they're experts in private investigation, they're experts in police tactics. They're just experts in everything, and the courts don't always do a good job of policing those types. So that just means that there's not a whole lot you can do except do good, solid forensic analysis, use some validation, use some quality assurance, you respond to their opinions, calmly, professionally, and with confidence. That's really all you can do. You have no control over who the court allows in as an expert. All you can do is just present the evidence as you see it, present your opinions confidently, and then just the rest is out of your control. You really can't do anything else about it. Okay, so that's it. That's all for the presentation. And looking at our Q&A, how often does defense ask for your notes, or is the report we write good enough? Because after I write my report, I shred my notes because everything is in the notes. I don't get asked for notes that often, but I mean, if you're in a criminal case, I mean, I would really advise against destroying your notes. I think that's another, I don't really see the benefit of that, because your notes, you're an expert, so your notes are, you know, going to have your expert notes in it, and those typically can be useful down the road. But yeah, I don't get asked for notes. I haven't been asked for notes that often. And then, but it's definitely possible, so be prepared. Okay, you spoke about reimaging a chip at shower pauses that had failed. Remember chip, how long after the original was done did you do it? So you need to get a search warrant approved. I expect if you have consent of the owner of the device, search warrant is needed, but absent consent. So yeah, so in this case, this was a criminal case and I was on the defense. So basically we conferred with, basically it was our client's device. So the chip belonged to the defendant who we were representing. So there really wasn't an issue with search warrant. But yes, if you run into this problem where you've done this process and you notice several months later that the imaging failed for whatever reason, then yeah, you would want to definitely be considering, okay, how do we approach this from a legal authority perspective? Talk to the prosecutor about it, let them know what's happening, and make sure that you're good to go on that. Okay, so thanks everybody for joining. And we'll please check out the website. Please take a look at, you know, if you like this presentation, if you think I did a good job, you know, do me a favor, take a look at the website. If you're in forensics, take a look at our lab management software. Feel free to sign up for a trial, or feel free to reach out to me personally and ask any questions or set up a demo, whatever you want. And we'll be happy to help you out. Hopefully this presentation was useful to everybody joining. It's going to be recorded as well, so it'll be available later. But lastly, just thank you for coming, and I appreciate the time.